Hi. So today I am going to share with you about the difference between contract of indemnity and contract of guarantee, and how you can use it in agreements, especially for buying and selling immovable properties. If you change the theme of an agreement from contract of indemnity to contract of guarantee, then you can decrease the damage that is caused by the default in performing the agreement of sale. Generally speaking, agreement of sale is between buyer and seller, and whosoever promises will be called the promiser, and the other party is called the promisee. If the buyer promises to perform the agreement or some parts of the agreement or some clauses in the agreement, buyer becomes the promiser and the seller becomes the promisee, and vice versa. The theme of agreement of sale is a contract of indemnity. Indemnity means damages. Indemnity means whosoever is redressing the damage that is caused to the other party is indemnified. So generally speaking, any agreement of sale for the sale or purchase of immovable property is a contract of indemnity. There are only two parties in a contract of indemnity. Today I am going to share with you how you can make it a contract of guarantee. In a contract of guarantee, there will be three parties. Contract of guarantee is a general term that is used in financial transactions. There will be a debtor, that is the borrower. There will be a creditor, that is the lender, and there will be a surety. If you incorporate surety in agreement of sale of immovable property of your house, land, or plot or flat, then you can convert that agreement of sale into a contract of guarantee, and any default by the buyer or the seller, surety stands and or enters into the shoes of the debtor. So there are three agreements in a contract of guarantee. One is between the debtor and the creditor, and the other is the creditor and the surety, and the implied agreement between debtor and the surety. Because if surety pays the amount to the debtor, hypothetically speaking, if the debtor defaults and surety pays the amount, then debtor is liable to the surety, because surety enters into the shoes of the creditor and becomes the creditor. So in real estate transactions, not only in financial transactions, in real estate transactions, while entering an agreement of sale, if surety is insisted, because when a property is sold, who can default is estimated. If the property is high worth property, the default is from the buyer side, and in those circumstances, seller can ask for surety in case buyer defaults. So high worth properties can be converted as contract of guarantee, and low worth properties can be converted as contract of indemnity. In a low worth property, seller defaults, and in high worth property, buyer defaults. So in a low worth property, my advice is to make it a contract of indemnity, and in a high worth property, make it a contract of guarantee. It could be anything, it could be bank guarantee also. So if real estate transactions or an agreement of sale is based on these concepts, instead of indemnity, if it is a contract of guarantee, then the chances of failure will be very less. Supreme Court in a recent decision in an Anand Rathi case, Maitreyi Doshi versus Anand Rathi case, distinguished between contract of indemnity versus contract of guarantee in a principle form. Though the judgment doesn't apply to the example here, the principle what I explained right now, if incorporated in agreements, then I think there will be less chances for failure. Hope I'm clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.